Well, hello and welcome to Polity Matters. My name is Ben Ratliff, and I'm joined by Jared Nelson and Scott Edberg and one of our fourth co-hosts, Fred Greco. Welcome, guys. Good to see you guys. We're in the throes of GA prep season. NomCom was this last weekend. I mean, how's everybody feeling? I've got a Presbytery meeting in May that I've got to prep for, so I can't quite see to General Assembly, but the rest of y'all have your sights firmly set. I mean, everybody's... How are we doing?
Doing good.
Watching the overtures list grow, Ben. And
Yeah.
I have a Presbytery meeting in mid-April in which I think the under is 2 overtures and the over is 4 overtures that I'm going to submit to the General Assembly.
They're all constitutional. You have no pontification, no declarations.
No, I only do amendments to the book.
No overtures to make Polity Matters the official PCA podcast. I'd entertain that one.
So would it be a constitutional amendment if I had an overture to add to the RAO an ice cream social?
I think a friend of mine probably has a draft you could make use of if you needed something like that.
We'll add 5. There's a fifth.
Would we leave it up to the discretion of the host committee, or would we have to specify what type of ice cream they would have?
I think it requires a subcommittee of its own. Yeah.
Its own COC.
own designated funds. Yeah.
Scott can create a spreadsheet of the various types of desserts.
That's right. He doesn't have a spreadsheet to maintain anymore, so he needs a new endeavor.
I'm just twiddling my thumbs. I'm not doing anything these days.
Yeah. Jared's here too, by the way, guys.
I'm advocating for some frozen yogurt.
Type.
Well, we are jumping into BCO 35 today and talking about evidence. I was reading around and came across a Ramsey quote where he says, "It's not easy to exercise discipline, but to discipline the church must come. And it is here insisted that we have the usable machinery of discipline, and all we need now, is the spiritual power to make it efficient." Just a good reminder that what we're doing, even though it is going to sound very technical and there's a lot of qualifications and accommodations, what we're doing is still spiritual work, even though we're getting into things that are going to sound kind of like you've seen them on TV before, evidence and such. So let me jump into BCO 1 and then 35-1 rather, and then I'm gonna give Fred our first question after that. 35-1 starts by saying, "All persons of proper age and intelligence are competent witnesses, except such as do not believe in the existence of God or a future state of rewards and punishments. Either party has the right to challenge a witness whom he believes to be incompetent, and the court shall examine and decide upon his competency." My first question, Fred, kind of jumps out of that Ramsey quote where he's encouraging us to remember the spiritual nature of our work. Why is belief in God and belief in a future judgment necessary for competent testimony in a court of the church?
Well, every court has to have some mechanism for making sure that witnesses who give testimony are telling the truth. And I think what has been lost by some of the advocates who say, we shouldn't have this requirement, it's not a requirement in our civil courts or criminal courts, is that our civil and criminal courts have a mechanism to compel truth. It's called perjury. And if I go and testify in a criminal case and I perjure myself, I can go to jail. I can be charged. And a ecclesiastical court has no ability to do that, not only because there's no mechanism, but because the church has no authority in that realm. Its authority is ministerial and declarative. So it has no mechanism and should not have a mechanism to punish anyone who gives false testimony. So the way that ecclesiastical courts handle this is to be assured that the person testifying is under the conviction that if they lie, they will be called to account for it finally. Now, you'll note here that this is not a requirement that every witness be a Christian. It could be someone who is secular, someone who is a Muslim, someone who is a Buddhist. They just have to believe in a future state of rewards and punishments. That's very vague. I may think that I'm going to be reincarnated as a grasshopper if I lie. And that's a future state of punishment, and that would qualify it. So, there are very few persons here that this applies to. I can believe in the most amorphous, fuzzy way in the existence of a God, of a higher power, of a big guy upstairs, of a creator, and I could think the Bible is an out-of-date bunch of malarkey.
Thank you. Children listen. So
and I still can testify if I believe in the existence of God. And so, and this has to do with their competency. It doesn't have to do with their willingness to testify. It has to do with their competency before a court. It's similar in that sense that if there were a young child who were not judged to be competent because they're not of proper age, they didn't, understand actions and language and consequences, that doesn't make them less of a person. That doesn't make them unimportant. It just means that the court can't make determinations based on their testimony. That's why you see here the last sentence, I think, is very applicable. Either party has a right to challenge a witness whom he believes to be incompetent, and the court shall examine and decide upon his competency. So, if, for example, a Muslim comes forward and the opposing party says, no, this isn't a Christian. He doesn't believe in the God of the Bible. You can't let him testify. If the court is convinced that he believes in the existence of God, then he's competent to testify, and they can take that testimony. Now, one latter point that will come up later is it's up to the court to judge that credibility, which is different than competency. So someone can be competent to testify, and the court could find them completely uncredible and could hear all of that testimony and say, nope. It could be their demeanor. It could be what they say. It could be what they say is contradicted by other evidence. I have seen instances where verbal testimony has been contradicted by a videotape. And, you say, well, no, I'm not going to make that credible testimony. So, there are multiple things going on here. And I think we've tried to tinker with this provision now at least 2 years, maybe 3 years running. And, I hope we take a pause from that because of what I'm talking now. And then we'll pick this back up again in 35.4. There's another matter that I think is important with respect to witnesses as well.
Yeah, and 35.1 already offers a lot of latitude. It doesn't set a particular age or a particular intelligence. It allows the court to evaluate that on their own accord. And so there's already quite a large latitude, whether it be what faith you subscribe to, what age you are, and your intelligence. The court has a lot of tools already in order to discern a competent witness. Really, the one group that is excluded would be those, or maybe two groups. So the one though would be atheists who deny any sort of rewards and punishments in the afterlife, or infant children. I mean, there's not a lot of people left to carve in because most of it's already been allowed in our court. And so sometimes when we're talking about this, we're already kind of in the middle ground, in my opinion, as we look at the current revision in 35.1. There's really not much more to give outside of atheists themselves.
And I think, and you all have done other areas of the rules of discipline, and it's true here too, that it's in the discretion of the court, as my good friend from Jackson, Mississippi says. And it's true here. So, for example, if you had an 8-year-old testify, and that 8-year-old was the only witness to the events, a court might be broader in its latitude and say that witness is competent. In another case where there were 6 adults who could also testify to it, the court might have less latitude and say, well, we don't really need that testimony, and so, we don't think in this instance this young person is competent. There is a lot of latitude for the court, and I think that is wise.
Well, it is interesting that now there's only 4 things that are listed here. Old enough, intelligent enough, believe in God, future reward. The original in 1820 actually had 7 different qualifications on it. There was age, I think disability says by want of any senses essential to the knowledge of a matter. I guess if they're blind, they can't be an eyewitness or something like that. Intelligence 3, 4, infamy of character, 5, if they're under church censure, 6, if they are a near relation, and 7, a variety of considerations which cannot be specified in detail. So they just left all that in there. And then later they narrowed that down to those 4 of saying, I think we made this a little bit too broad to, just dismiss here. Let's just make these categories into 4. And those are the 4 that they found to be most relevant there. But I also think this is to get testimony in a particular trial, but there's other ways to get evidence, isn't there? If you have, I think you mentioned it earlier, maybe a child is too young to testify to something, but if you have the video of it, you don't need that. Or if they've given some sort of testimony in court, if this is after some sort of a civil matter, you have those documents, you have their decisions. This is just, if there's particular testimony that you need to get for some reason in ecclesial trial, here's how to get that narrow avenue of evidence, but there's other avenues if you can't do that here.
That's correct. That broader area is under 35.4. I would just say one thing. You're right, Jared, but the language we have is also not new language. It's language that Ramsey cites in the 19th century. So this language has served us well for more than 150 years.
Yeah, since 1858, I see on there, yeah.
Yeah. So you are correct that it has been narrowed down, but it's not like the PCA did this, 40 years ago.
Yeah.
35.2, the accused party is allowed, but shall not be compelled to testify. But the accuser shall be required to testify on the demand of the accused. A husband or wife shall not be compelled to bear testimony against one another in any court. All right, so, every TV drama that I ever watched that has to do with a courtroom, it's all, there's always like this dramatic moment in it where it's the guy being accused and charged. He hasn't been testifying because, of course, that's a bad idea. And at the last minute, he goes, I'm going to take the stand. But it seems that this guy, they're not compelled to do so. The accused in this particular case. Is it a good idea to do that? Can it be helpful? Is it generally advised for accused individuals not to testify in their own court trials? Just kind of want to think through that first part about the accused.
Well, there's 2 things here. First, obviously, the accused may not want to testify because he doesn't want to come under cross-examination. That's really the thing they're trying to protect from. And in cross-examination, you're not sure what questions you're going to get asked. Secondly, you've heard me say before, and you will hear me say again, I wrote that provision. This is the opposite. I wrote an overture that failed. I tried to amend this section of the book to require an officer to take the stand in doctrinal cases. And that made sense to me because if a man is being accused of aberrant doctrine, he should be compelled to testify as to what his doctrine is. But that failed. It did not make it past the General Assembly. I think for a number of reasons. I don't want to speculate exactly, but I think there were a number of reasons why people came together and defeated that overture. So I think there could be instances in which it would be advantageous to compel the accused to testify. But I do think this here is in line with our common jurisprudence in which, you can't make someone testify. And even in proceedings which aren't covered by the ability against the prohibition against self-incrimination, like a deposition, the person being deposed can plead the Fifth Amendment. I refuse to testify on the grounds that it may incriminate me. Now, people watch that on, a legal drama on TV and they think, oh, he's guilty. He doesn't want. No, he may just be saying, I don't even want to open the door to anything here. So I think there is some advantage here in general.
Yeah. It's interesting to me that, and maybe these are not connected, but we can't convict a man of a charge unless he's present in the trial, right? That's why contumacy exists. But then at the same time, when he's there, you can't compel him to take the stand, so to speak, and testify in that same matter. I realize there's other things going on, but
Well,
Anyway,
this seems to
Jared.
also be a big protection for people in the congregation. They're accused of something. They're not going to get a grilling here as somebody in the congregation. There has to be the evidence already had to have been there to get to that point. And so I see this almost as a protection, especially against a church member that is just afraid and nervous. It's different for a pastor defending his doctrine, but for somebody in the pews who might get nervous, have anxiety, whatever it may be, this is a protection for them.
And that could be a point of pastoral awareness for men as you're going through discipline with your congregation. Inform people of this right that they have, that they don't have to stand up and they can just sit there the whole time, and let it happen. And so that sounds horrible. Let it happen. That's not what I mean. But just if there's not good evidence against you, then trust the system to some sense.
Is there ever a good time to testify as the accused? What's the strategy there? I'm just curious.
I certainly think there could be. If someone was accusing you of something and you had evidence that would show your innocence, then certainly, you want to describe that. That could either be factual, I wasn't there at that time, I was in another place, or because this, in an ecclesiastical trial, intent is very important with respect to sin. Someone could testify and say, I know I said X, but that's not what you think I meant by that's not what I meant by that. I use that phrase in a lot of contexts. People know I do, etc. So I think you could give context. So I certainly think there could be cases where that would be the case.
Yeah, and then the opposite is interesting here. The accuser has to testify if he's called on, because if you're making the accusation, you need to have the evidence followed up and be subject yourself to cross-examination on it.
It is good to note that there is a lot of weight put on the accuser, and it's because we see similar things attached to men who are voluntary prosecutors, right? It's a big deal, and if you don't do it right, you're liable for discipline. And so similarly here, you need to testify if you're called upon to do so. Husband and wife not compelled to bear testimony against each other. That's common in our civil and criminal courts, isn't it, Fred? Is that just pretty common generally that we don't compel them to testify against each other?
Yes, I think it is. And remember here, the language here is compel. So there's nothing that stops a husband or a wife from testifying. It's just that you can't compel them to. And I think that's rooted in common law. And quite frankly, it reflects an historical preference for the institution of marriage. So in other words, you can't compel someone to testify in such a way that could cause difficulty in their marriages or cause their marriage to dissolve.
35.3. This is where y'all can take a water break or whatever you may need. A court may, at the request of either party or at its own initiative, make reasonable accommodation to prevent in-person contact with the accused. A, the court may have testimony taken by video conference. The video conference shall employ technical means that ensure that all persons participating in the meeting can see and hear each other at the same time, and which allows for live cross-examination by both parties. B, the court may restrict the accused from appearing on the video conference screen, and when the accused is represented by counsel, cross-examination shall be conducted by that counsel. C, in all cases where such accommodation has been made, video conference testimony by witnesses under the age of 18 shall be taken by written interrogatory to be read to the witness by a person appointed by the court in accordance with the applicable provisions of BCO 3511. D, the court shall include in the record of the proceedings its reasons for this accommodation and any objection from either party. What we talked before we started recording that this is a recent addition inserted here into BCO 35. Let's maybe address first what scenarios, we don't need to be too detailed, of course, what scenarios are we envisioning in which a person would not want to have in-person contact with the accused?
I would think, typically speaking, that has in mind some form of an accusation of abuse. And this language is similar to what courts in the civil realm, both contract type cases and criminal cases, have applicable. And I think in the main, what you're thinking about are younger witnesses, someone who could be, intimidated by having their accused abuser stare them down as they're giving testimony. You can imagine that there are instances like this. Again, we can go to movies, when there's somebody trying to testify against a notorious gang member or a cartel member or some criminal overlord.
Fred Greco.
And they don't want to be, have them, get stared down. There's a very famous scene in the sequel, The Godfather 2, in which Frankie is giving testimony and Michael Corleone's in the room, and Frankie looks at him, and there he's not intimidated, but I think he realizes that Michael is going to help his family if he changes his testimony, and he does. And then the government lawyers go ballistic because he saw Michael and recanted his testimony before that congressional committee. So I think those sorts of instances are where this matter would come up. Although I will say it's not exclusive to that. If you look at 35.3a, that could be applicable simply to someone who's at a distance from the court. That you don't need to fly somebody from Atlanta to Dallas to give 30 minutes of testimony. It could be done via a video conference. And you'll note that the language there, which is used in other places, so for example, about meetings of session and presbytery, the language is similar there that I've drafted and it was approved, that there needs to be an ability to hear and interact so that the cross-examination can still go on. The sense is this isn't, a shortcut and it doesn't cause a problem for one of the parties. It's just they're not physically in the room. And I think this has become very comfortable for us because more and more we have meetings and interviews and college classes and so many things are done via distance over a video conference that we become very familiar with that.
Isn't it true that almost all the SJC matters, panel hearings, et cetera, happen over video conference these days? Can you remember the last time y'all had an in-person?
Our panel hearings are almost all via distance.
Yeah.
I will say that the first and only trial we had was an in-person trial.
Yeah.
So this is a little bit different. This is giving testimony.
Sure.
But that does also speak to the fact that it's, we're so comfortable doing these things that no one worries that we won't have a good hearing if we all don't fly to Atlanta to sit in one room.
Yeah. And so you get into B and C and D, and there's some more issues. So you can all be on a video conference. B says, okay, maybe the accused needs to not be visible on the screen and represented by his counsel when he's interacting with the testifier, the witness, excuse me. And then especially C, when they're under 18, you can take written interrogatory. So what is that? The counsel provides questions that are answered and then given back to the court, and it can be given in the way of 3511, which I assume has to do with some other kind of testimony off the top of my head. Yeah.
Yes.
Which we'll get to. Sorry, I'm not trying to ramble. I just don't want to skip through all these without our listeners having some sense of what each of these paragraphs means.
And I think it's important to note that this section was the subject of intense debate, amendment, etc. in the Overtures Committee. So men worked very hard to come up with this language. And it wasn't even just the men on the Overtures Committee. This was proposed in a year in which I was not on the Overtures Committee. And I think I joked on social media, I felt like Tom Brady after he retired. I'm sitting there having to watch the game and I couldn't play. But I do remember sending, pretty detailed markup of this language. I worked with Teaching Elder David Coffin on that and some others. So a lot of hands were on this and a lot of eyeballs were in it. And I think we ended up with a pretty good provision.
35.4 and 35.5 together are talking to us about weight and judgment of evidence. So I think I'm going to read these together, 35.4 and 35.5. The testimony of more than one witness shall be necessary in order to establish any charge. Yet, if, in addition to the testimony of one witness, corroborative evidence be produced, the offense may be considered to be proved. And then 35.5, it belongs to the court to judge the degree of credibility to be attached to all evidence. So let's start first with this idea of corroboration. Why, surely there's a biblical principle behind some of this, right? Why is corroboration required for testimony?
So this is an important provision here. I think this is part of where people get sideways about 35.1. So the Bible says that 2 witnesses are required. Actually, 2 or 3, but if it's 2 or 3, you can have 2. Mm-hmm. And we think 2 or 3 witnesses, Bob needs to stand up and testify, and Joe needs to stand up and testify. That's not what the Bible requires, and that's not what our book requires, because a witness could be physical evidence or a document. So if it were a murder trial, one witness could be a person saying, I saw him with the gun in the study with Colonel Mustard. And someone else could say, well, here's the blood spatter report or the ballistics report from this. And it could be introduced into evidence. And so documents, physical evidence, they count as a witness. And so when you start thinking about that, the requirement to open up witnesses to anyone is reduced. Now, let me take it a step further. The rules of evidence in ecclesiastical trials are not the same as the rules of evidence in civil trials. What do I mean by that? If we were in a civil trial and I was testifying and the prosecutor asked me, well, how do you know this happened? And I said, well, Scott told me it happened. That would be inadmissible as hearsay. Scott would have to testify that it actually happened, unless it fits a small number of exceptions. As Scott was dying, he made a dying declaration. As Scott was making a declaration against interest, maybe talking generally against spreadsheets, for example. That could be something like that.
He recants on his deathbed everything he's ever done.
But that's not required in an ecclesiastical trial. I can give hearsay testimony, and the court can accept it and judge it as credible or not based on the person giving the testimony. It's not automatically excluded. And so, the parade of horribles that there's, the non-Christian maid that has seen this event and somehow that can't get into evidence. If she tells a Christian neighbor, the Christian neighbor can testify and say, the maid told me, and it could come in. It can also be such that if the maid gives that report to the police report can be brought into evidence. The hospital report could be brought into evidence. The doctor could testify. So, it's much broader than what we're used to seeing on Law and Order or Perry Mason when someone stands up and yells, I object, hearsay. In a normal ecclesiastical court, they'll say, no, thank you, sit down, we'll judge that. There is no hearsay rule. People don't know that. And that's actually pretty important. It opens up. And this is where you've taken 35.4 and 5 together, Ben, and I think that's a good way to look at it. Because what's really at instance there is not whether something is permissible or not, but whether it's credible or not. So the court may say, well, yeah, okay, you say Scott said it, but we don't believe you. Because that's an advantage to you to say that. If Scott's not here to testify, we're going to discount that testimony. And so, I think this is really important.
I could use help from listeners. If anybody wants to write in and let me know what a Perry Mason is, I would appreciate insight into that. Thank you.
It's like a Matlock.
Whippersnapper.
I was going to ask Scott what it was, but I thought that would be just us making fun too much. Can we think through? I realize that all of the answer is Dr. Waters' answer. It's up to the discretion of the court. What are categories that might be helpful for men to think through? So imagine we've got ruling elders, teaching elders listening that haven't ever had to do this before. What are categories that are helpful for them to have in their minds as they think through how to judge something credible in terms of evidence?
I think the largest overarching category that covers everything under Dr. Waters' admonition of discretion of the court is the court should ask itself the question, is this something that raises a grounds for appeal? So for example, if you allow that document, is the other side liable to object? And would a higher court think that you were abusing your discretion? And my advice to courts is to be very careful with their discretion and to limit the possible grounds for appeal. You may not need every piece of evidence. So you may admit a document that is, an abuse of your discretion, and you don't really need it to come to a decision, but you just raised the grounds for appeal. And if that appeal is sustained, you've just lost all your work.
Guys, any other thoughts? Jared, did you just open a beer, by the way? That's what it sounded like. Okay.
5 o'clock somewhere, Jared.
A Celsius, because I'm tired.
Celsius. Yeah. That's our sponsor of today's episode, actually. Celsius.
Drink Celsius.
Healthy energy.
The caffeine of quality matters. Okay. Okay, good. So evidence, weighing it, judging it. Let's keep going into 36, into 37. So let's see. In my notes, I have these combined. I think I'm going to read
6
these
and
combined
7
as well. Did I say 6 and 7?
It's at 36. So 35, 6, 35, 7.
Oh boy!
Just to be pedantic.
Can you send me another one of your extra
Celsius.
Celsius? Could use one of those.
How many times can we say Celsius in this episode?
35
Height.
Celsius. No witnesses afterwards to be examined, unless a member of the court shall be present during the examination of another witness on the same case if either party object. Well, let's just stop there and handle that real quick. So sometimes judges sometimes members of the court are witnesses, and they can be present when other witnesses are being examined, but generally speaking, witnesses can't be present when other witnesses are being examined. And I guess the question would be obvious to us, but why? If anybody wants to jump in and just kind of explain why sequestering witnesses is important to a case.
So I think that there are two things going on here. First, it previews 3513. In that a member of the court is not automatically disqualified when they are called to testify. We can talk more about why that would be later. And so that means that if a member of the court, if he's called to testify, if he's still entitled to vote, he's got to hear the other witnesses. That's a requirement.
Yeah.
So you couldn't exclude him because then he wouldn't be a proper judge. Okay, and we'll deal with the disqualification in 3513. But here, for anyone else, that is to prevent witness tampering, whether intentional or unintentional. So, someone hears Joe testify, and then an hour later miraculously testifies to the exact same fashion. You can't do that. But it also means that it adds credibility actually to the witnesses, because the other party can't say, well, he's just saying what the other guy said. Well, he may be, but he didn't hear the other guy say it. So that actually means it probably did happen, because two people independently said the same thing. Mm-hmm. And so, this is the case. And this is one of the reasons why in an actual trial you have a list of witnesses. This is another instance in the book in which you're supposed to, list out your witnesses, not everything they're going to say, but so the two parties know who's going to be called, and they make sure those people aren't in the room. That's a very practical application of that rule.
Yeah, and this could be on the other side as malicious too, right? Somebody says, these guys are all out to get me. Well, let's have them not listen to each other's testimony or to your testimony and independently hear these witnesses so that it doesn't seem like they're just trying to contradict you for the sake of it.
Right. Yes.
Well, listeners, as our well-ordered Polity Matters schedule spreadsheet says, this podcast is over. Thanks for joining us. Be sure to tune in next week when we finish up our discussion on BCO 35.7 through BCO 35.16. As always, we are eternally grateful to Fred for his contribution to this episode and many others. If you've enjoyed the show, please consider following us on Twitter and Facebook at Polity Matters, and be sure to subscribe in your podcast app of choice. If you have questions or comments, you can contact us at any point by emailing us at politymattersfeedback@gmail.com. There's also a link below where you can support our work if you'd like to help us out. Thanks again for spending your valuable time with us. Until next time, y'all take care.